Okay, welcome everyone. My name is Tony Reeves, and I am a full-time real estate investor. I've been doing this for 18 years, and today we are going to talk about trusts. Trusts are a estate planning tool. They are not an asset protection tool. I want you to be cautious of that, because if you use them with the intent of asset protection, you can run afoul of the law, and the courts could actually undo what you have done. So I want you to understand that this is an estate planning tool that we are working with today. The other thing I want you to understand is that I am not, although we're going to be talking about things that have potential legal impact and ramifications, I am not giving you legal advice or accounting advice. Today what we are discussing are some estate planning tools that I have used in my real estate investing business. It is also giving me some benefits, and what we're going to talk about are some of the benefits that I have been able to experience in this process, and some of the things that did not necessarily work out for me well. Okay, let's get started. Welcome on your road to success. And the first item that I want you to realize is that trusts are just merely a title holding entity. They do not provide asset protection like a corporation or a LLC might give you such protections. The first thing that we need to understand is that in controlling, holding, and protecting your real estate, I want you to be careful and understand clearly how lawyers work. If you're sued because of something that is your fault, an accident on your property, or as a result of your job, attorneys will sue you. If they file a claim and win, they will try to collect from your insurance policy. That's your first line of defense. However, if insurance is not enough, or if you don't have insurance, the attorneys will come after your assets personally, whatever they can find. Your salary from work, your home, cars, bank accounts, pretty much anything that's in your name. If you suddenly transfer them out of your name to your spouse's name or that of a relative, it may be too late. The courts may say you tried to hide your assets or you conveyed them fraudulently. So the time to do estate planning is before there is an accident or injury. You know, I want to correct that. Even if you have not received notice of a pending lawsuit or that someone is going to sue you. Let's say you get into a car accident. The next day you go to City Hall and you transfer your assets out of your name into the name of someone else. That is going to be an indicator to the justice that you may have been trying to hide assets, and they could go back, they could roll back the hands of time to the status of those assets prior to the litigation, at which point they would give access to the person that's suing you to those assets. Okay, so it's a good idea to try to take care of these things before an accident takes place. Okay, the next thing is a general partnership. Oftentimes general partnerships are used when we go into business. It's the simplest and the easiest business entity to set up. One of the major advantages is that it's simple to set up. All I need is a business card with your name and my name on it, and we're in business. I don't really have to do anything with the state to let them know that we are in a partnership. That's also a big disadvantage. See, what happens is all the partners are generally liable for the actions of others. That means if my partner is out riding around town, gets into a car accident, and it's related to our business, I could be held liable for that person's actions. And if I have deeper pockets, this can be discerning. Now, the next form of partnership that makes greatest sense for real estate people is a limited partnership. See, with a limited partnership, the general partner that's out and about, hopefully the one that has fewer assets, is the general partner. And should something go wrong, they're going to go at that general partner's liability because he's the one that was generally taking care of business. The limited partner may have only been involved to the extent that they invested some cash into the entity. That's all. No other obligations. Okay? Limited partnerships are a little bit more difficult to set up. You actually have to file some documents with the state, letting them know who the partners are, who's the general partner, what's their degree of liability, how much do they have invested in the entity, and you're also going to let them know who the limited partner is, and what do they have invested in the entity in question. Okay, let's move on to the next asset protection item that most people look at these days. LLCs are very popular amongst many investors. The biggest advantage for LLCs is that they're not that difficult to set up. They're actually the best way to own real estate amongst corporate entities. Okay? They provide liability protections, flexible tax advantages. The disadvantage that most attorneys said when LLCs first came out is that they were recently enacted statutes, and judges' interpretation on issues are still up in the air. It's still open. There's not enough case history. That's not really the case. If your limited liability company was set up to run as a sole company or corporation, then you'd probably be governed under corporate law if there's not enough case law or statutes. If, let's say, your LLC was set up as a partnership and an issue arose that didn't fall directly under the LLC statutes or case law in your jurisdiction, then you would assume that a justice would probably use some of the traditional partnership statutes or case law to apply to your situation. Now, so LLCs now are a pretty good entity for investors to deal with. Although I think that there are not necessarily the best way to hold title to a single individual property if you have single family rentals and things of that nature. Let's talk about the next entity that's out there, corporations. Corporations are another form that investors and just small business people like to use. The property is not in your name. That's an advantage. An S corporation has many tax advantages, such as depreciation that passes on to the owner. Doesn't necessarily stop at the corporate level. It can be passed on to the owner, kind of like a pass-through. Big liability protection. When people see corporations, they understand you have protection. Giving away and selling is made a lot easier with a corporation because you can sell shares of that entity pretty quickly. The disadvantages of a corporation: cumbersome taxes and paperwork. You must sign personally on loans. You must insure the corporation itself separately. If not, a judge could very easily pierce the corporate veil and hold you personally liable. And this is with most entities that we're talking about today. Okay? Now, the entity that I like so much are trusts. And I want to show you the statute that actually allows us or permits us to transfer our assets to a trust. And I kind of misspoke. This is not actually the statute. The statute is the 12 USC, okay, right here, 1701J, and it's the due on sale clause for the Garn-Saint-Germain Act from 1982. We're actually focusing on the exemptions. Here's a little rule for you. If you are looking at a statute or someone saying a law applies to you, the first thing you want to do is look at the purpose of the statute and see if it applies to you. For example, there was a document written a long time ago that starts off, "We the people, in order to form a more perfect union." What does that mean? That means the remaining document only applies to we the people. And the purpose of that document is to form a more perfect union. So if you're an animal, this does not apply to you. All right. The other aspect of statutes that you may want to take a close look at are the exemptions or exceptions to the statute. And that's what we're looking at here on item D, exemption of specified transfers of dispossession. This is an exception to the overall rule. And the reason why you want to look at the purpose or the exemption is you can immediately, quickly either put yourself in a category or remove yourself from that category of the particular statute that you're looking for. In this case, we want to remove ourselves from the Garnsey-Germain Act by looking under the exemption. Why is it this statute should not apply to us? And if we jump down to item 4, it says granting of a leasehold interest of 3 years or less, not containing an option. For you all that do lease options, this is a key clause or paragraph for you. But we're talking about it in relation to trust. So let's look at item 8. A transfer into an inter vivos trust in which the borrower is and remains a beneficiary, in which does not relate to a transfer of rights and occupancy. What are we saying here? We're saying that the Garnsey-Germain Act allows you to transfer your property to a trust and not be in violation of the due on sale clause, so long as you are in conformity with item 8. Item 8 says it's a transfer to an inter vivos trust. Great. In which the borrower, that means the person that took out the loan, is and remains a beneficiary. So what it's saying is, when we transfer the property to a trust, the person who took out the original loan must remain, the borrower must remain a beneficiary in that new trust item we've just created. That might seem problematic, but we're going to talk about how to address that a little later. And which does not relate to a transfer of rights of occupancy. What this is saying to us is that the trust document we create retains the borrower as the beneficiary, and the trust document that we create does not give away the rights of occupancy of our borrower. That means he still has the right under that document to retain occupancy of the subject property. Okay, let's get ready to move on to a couple of cases involving the Garnsey-Germain Act. The first thing I want you to understand is that you can come up with a law or a statute, but until it's tested in court, you really don't know how it's going to come out. So in this case, in 1978, there was a Cynthia Wellenkamp who was in litigation with the Bank of America. And what the California courts found, declaring essentially in favor of Cynthia Wellenkamp, that neither private lenders nor state or federally chartered banks could enforce their due on sale clauses. So this basically upheld the Garnsey-Germain Act. It said they couldn't do it. Okay? They can't say, if you transfer your property to a trust, we can call the loan due. The other thing that took place in 1982, Fidelity Federal Savings Loan sued Mr. De La Cuesta. And in this particular case, the courts overturned Wellenkamp, but only with regard to federally chartered savings and loan associations. They need not adhere to state statutes if federal home loan board regulations differ. So that means in some states, you could transfer your property to a trust where the loan was held by an S&L. In other states, you couldn't. Now this is challenging. What I really feel is that this is a fine line distinction. Mr. De La Cuesta apparently made someone pretty mad. The savings and loans pulled their financial resources together, got a really good attorneys, probably from the funds they were able to pull from other savings and loans, and said this is going to be bad. If people are allowed to transfer their assets to trusts and we can't stop them under the due on sale clause, we're going to be losing money. Remember, what was going on in 1982? Were interest rates a bit high? Investors were buying properties subject to leaving the interest rates the same low rates before 82. And the banks were losing money, so they had to act so that this Garnsey-Germain Act didn't cost them too much money. I imagine Mr. De La Cuesta did his little transfer, probably danced in front of the SNL, talking about how he saved so much money because he just took over his seller's mortgage through this trust thing. They got wind of that, pulled their money together, and said, we got to stop this here today. But the thing to notice is it was such a fine line distinction. It only applied to savings and loans, not to other FDIC insured institutions, which is kind of strange because the distinctions are so minor. I mean, they both had bank checking accounts. They both had savings accounts. You could write checks on both of them. You could get ATMs, funds, or card to draw your money out from both of them. The only distinction is that one was insured and one was not federally insured. Okay? So here's a hint. Take this away. You can still do it with a trust. If you have a savings and loan, questionable. Not too many savings and loans around now these days anyway. The other point is, you may keep in mind that not to run around telling everybody what you're doing if you transfer your property to trust. Now, let's get to the matter at hand, the meat of the matter. Trust. Land trusts in particular. First of all, I gotta tell you, this slide should probably be changed because there's really no such thing as land trust. If you walked into an attorney's office and say, I want a land trust, in most of the states in this country, they're going to say, what's a land trust? See, for the world of lawyers, there's only two types of trusts. There's a living trust, and which is also known as an inter vivos trust, meaning a trust that's created while you're alive, and there's a testamentary trust. That's a trust that is created upon your demise. For us as real estate investors, we're talking about an inter vivos trust created while you are alive. Okay? A land trust or an inter vivos trust is a real estate ownership arrangement for a definite term whereby a trustee with full power of sale holds legal and equitable title to a property under the direction and control of the trust beneficiaries. The trust beneficiaries hold only a personal property interest in the trust. They do not own the asset in question, but they can direct the trustee on what to do with that asset. Most cases. There's a few instances we'll talk about later where the beneficiaries should not tell the trustee what to do. Let's look closer at the types of trusts. The inter vivos trust is a living trust, as I stated earlier, that's established during the life of the grantor. The other trust that we spoke about, down here on the bottom, is a testamentary trust. That's a trust defined in one's will, whereby a trustee is appointed upon the death of the grantor to manage the assets following the grantor's death. Now the two items in the middle that we're looking at, an irrevocable trust and revocable trust. An irrevocable trust is any trust in which the grantor is prohibited from revoking the trust for at least 10 years. A revocable trust is a trust that can be revoked by its grantor at any time. So therefore, most of the time we as investors are going to spend our time with the revocable trust. Now, let's begin to talk about how it works. The first thing is that the owners will place properties into their trust, their own trust, a living revocable trust, right here in the middle of the screen. Then, the owner will deed the property to the trust and the trustee who holds bare title. He's now the legal owner. Okay? There's a document, which is that trust document, that tells the trustee how to deal with the asset, the trust. Now, the power of direction can go from the beneficiary down here. They may have direction, okay, to tell the trustee what to do. Now, this is the situation that I said earlier. There may be an instance where you don't want the beneficiary to tell the trustee what to do. For example, my parents have their home in a trust. Most of our parents would not want the children telling them what to do with the asset. Therefore, in this instance, the beneficiaries, my parents, have the ability to tell the trustee what to do. But there's some instances where you don't want the beneficiary to tell the trustee what to do. For example, your estate. If you have children, and let's say your brother-in-law becomes your trustee upon your demise, well, he's the trustee for the benefit of your heirs, your children. This is a scenario, if your children are minors, where you probably don't want your 9 and 10-year-old children telling your brother-in-law, the trustee, what to do with the assets, with the estate, the house. He could find himself in a very challenging position. The kids might say, sell the house, let's move to Disney. And he'd have to oblige. In this instance, you may want to consider having someone else named as the person that has the direction of power. Maybe another family member might tell the trustee how to manage the assets for the benefit of the children. It could be an attorney, it could be a lending institution, or some other professional organization. Let's take a quick look at the parties to a trust so we understand who they are and what their roles are. The first that we have is a settlor/grantor. Remember on the earlier side, we said that the grantor is the one transferring the asset, transferring the property to the trust, the one creating the trust. The settlor can also be the one, let's say, probating a will. And in that instance, they may create a trust in that process, the testamentary trust. You also have the trust itself and the trustee. The trust itself and the trustee, those are the holders of legal title to the asset, but they're holding the title for the benefit of another. Who's the other? That other is the beneficiary, one who benefits from the act of another. And then the last item, party of our trust, is the corpus, or the residual, the remainder. That is the asset that is being held in trust. Okay? That's the asset that's being held in trust. Now, let's take a look at the documents that we use in that process. The trust documentations consist of the following. You have the land trust agreement. That's first and foremost. That's the document that outlines the relationship between the asset, the trustees, the beneficiaries. Okay? The second document that we're going to be looking at is your beneficiary agreement. That's the document that exists between the beneficiaries. It says this happens, then that happens. It might allow one of the children to live in the property, but both of the children to share in the distribution of that asset's wealth after a given point in time. It's basically like a partnership agreement. The last item is a deed into land trust. The deed into the trust is the actual transfer of the asset to the trust. You actually have to retitle your deed so that your property is transferred to the trust. This is how you fund the trust. Some of the times people will set up documentation and never fund the trust. If that happens, you have a failed trust, and a whole nother set of rules and laws apply to that. The last item that we haven't discussed is an assignment agreement. Remember early on in the Garn-St. Germain Act, under the exemptions, item 8 says where the borrower is and remains a beneficiary. Well, at some point, maybe when you give them the cash that they're looking for in their deal, you're going to want them to transfer or assign to you the beneficial interest in that trust, at which point they are no longer in control or entitled to the control of that asset. That's probably the time you want them to move out also, so that you can have possession of the property. Well, listen, I want to find out if you had any questions regarding what we've discussed here in what we call Trust Presentations 1. This is so that you can get a solid understanding of what trusts are and what they're all about. So, if you have any questions, by all means, okay, tune in to our free weekly conference call, And you can find out more information about that by visiting our website, www.yourlearningcenter.com. I want to thank you for taking the time to listen to this presentation, and I also want to remind you that you want to get started with your estate planning as soon as possible. Now is the time. Have a conversation with your parents. Let them know that if they want their assets to pass to their heirs, there's some things that they should do now so that they don't wind up having the state, through inheritance taxes and capital gains, diminishing the asset that they worked hard to pay off for you. The other thing is, if you have heirs, you want to do the same thing. Okay? Get your estates, your affairs in order, so that as you build your real estate investing profile, as you begin to make a go at this thing, you have taken the necessary steps to protect yourself so that if something goes wrong, your heirs are protected. Okay? Well, that's the end of part 1. Thank you for your kind attention. But now we're going to take a break, and we will be starting part 2, which is the actual documentation, filling it out and how it works. So, by all means, look forward to seeing you at Trust Part 2. Have a great day.